I have the ability to text him, um, and I got a text fairly late indicating that they came after him earlier last time, yesterday, than they have today, and he was concerned about it. My legal assistant just got off the phone. She says to me by text that with Lieutenant Opper, who is the person at the jail who is going to be retrieving Mr. Whitaker, and she is tending to it now, as I understand it. So I can't account for it other than to say that for whatever reason within their jail, they're a little behind, but I think it's in process.
Okay. Well, I can wait. We are all here. I might put you all back in the waiting room until I see him. But we'll at least give it some time, unless there's things you think we can do. I mean, there's a lot of exhibits if y'all wanted to do exhibit work, but we've been rolling okay on exhibits. I just don't know if y'all both looked at your exhibits and thought maybe we could pre-admit some that haven't yet been admitted.
Judge,
That would shave off some time.
To that end, last night I sent a text message to Ms. Locke indicating that I would like to offer all of the exhibits that are listed.
Well, you don't need to tell me that. I think you need to y'all need to talk.
Okay.
And y'all need to figure out if there's anything you can agree to.
Okay.
Because she still has some exhibits, I'm sure, that she wants to get in, and you have all your exhibits. But that's not a me thing. That's a you thing. I'm not going to, if you all want to agree, I could see where that saves you some time. If not, Miss Locke, your time is getting short.
Oh, I'm well aware my time is short.
Okay. But I don't mind if y'all talk offline about whether or not you can agree to some of exhibits. But that's only if I'm only going to do that if I could see the wisdom of it. But I'm only going to do it if you agree.
Okay.
If not, we'll just do it the hard way, especially because you put in 100 exhibits. And if I'm going to be 100 plus, and I'm going to be totally honest with you, a 2-day, even a 3-day trial, 100 plus exhibits is somewhat
excessive.
Ambitious. I was going to call it ambitious. Or unrealistic might be the right, because it's not possible for a jury or a judge to look at 100 exhibits, really.
Well, what I was hopeful to do with the spreadsheet is to have a source of documentation, a source of proof for all line items, and that's the way I created the spreadsheet. And so I was hopeful that if Ms. Locke and I shared.
Oh, Mr. Whitaker is coming in. Let me just letting y'all know.
And Judge, Mr. Case and I can talk. I don't know that we necessarily need the backup documentation for values, because we can stipulate to the current values as of today for purposes of the spreadsheet. But I think Mr. Case and I can take care of that on lunch break.
I'm
okay.
Fine with that.
All right. Well, it looks like Mr. Whitaker is at least arriving and is working on getting his screen up and everything.
Judge, may I ask, housekeeping wise, yesterday you said we were going to keep the same schedule today, and then towards the end of the day,
I can go later. I mean, I was dealing with that in real time. I actually saw Miss Weinman. She's in a case against a pro se, but she can't reschedule it today anyway, and so you have me all day, basically.
And lunch is from 11:30 to 12:30 again.
I mean, I think that's fine with me. If we need to move it a little, we can move it a little. I mean, I'm pretty flexible today. That's all. I guess that's what I'm telling you. I have a lot of flexibility. I can do a more traditional lunch that's 12 to 1 our time today.
We've been lining folks up around that.
That's fine. Then that's great. That works for me.
Okay. And may I ask, Your Honor, in light of the fact that we've been lining folks up and not knowing how long we need with Mr. Whitaker, et cetera, is it all right if I take some of those folks out of order if they need a specific slot?
Of course. That works for me. All right, then I think we have everybody here now. Ms. Racanelli, again, she's dealing with a sinus infection, and so she's going to stay off screen rather than be on screen. And so we are going to go ahead, though. She is here, and so we are going to go ahead and go back on the record at this time. And Ms. Locke, we're still in your case in chief, and you may call your next witness.
I call Mr. Whitaker.
Mr. Whitaker.
Show you what's been marked as Petitioner's Exhibit 14. And Mr. Whitaker, you have seen the incident report from North Carolina regarding the allegation you are currently under federal indictment for. Is that right?
I've actually never seen this.
Okay. Well, it's the Charlotte Mecklenburg Police Department Incident Report. It's a public release incident report as of 6/6/2023. And Judge, under the hearsay objection of public records, I would move to introduce Petitioner's Exhibit 14.
Your Honor, to the extent there are routine recitations, I suppose that's fine, but to the extent there are narratives, I'm going to object to hearsay within hearsay.
Right. I basically allowed you to do this yesterday over Ms. Locke's objection, so I'm going to stay consistent and overrule your hearsay objection as well. And the petitioner exhibit 14 will be admitted.
Thank you. So, Mr. Whitaker, on 5/20/2023, were you at a hotel motel at 7911 on WWT Harris Boulevard in Charlotte, North Carolina?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Okay. And you're aware that the person you met with on that particular date was 15 years old?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
And you're aware that you forcibly sought, right?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
This 15-year-old was hospitalized because of your actions, correct?
Under advice of counsel, I respectfully decline pursuant to my Fifth Amendment right against self-incrimination.
And she, in fact, suffered serious injuries from you.
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Okay. And you aware that the classifications of the incidences that she reported was statutory rape, correct?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Were you taking pictures of her with your cell phone while you were sizing her? Is that where the pornography and obscene material comes from?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Okay. And so were you, how did you meet her? Was it through Discord?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Well, you have a Discord account, correct?
Yes.
Okay. And how long have you used your Discord account?
Probably, I would say I used it from around June of 2022 until recently.
Did you also pay her for those sex acts?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Because one of the complaints is purchasing prostitution. Why would you pay a 15-year-old for sex?
I don't understand the question. Could you rephrase it?
Sure. Why would you pay a 15-year-old for sex?
Objection, Your Honor. It assumes facts, not an evidence.
Sustained.
Okay. Did you pay for her to get lifts from her location to your hotels?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Did you miss your daughter Desi's recital to go to North Carolina to raise a child?
Is that two questions or just one?
Okay. Well, let me break it up. Did you miss Desi's recital?
Yeah, I didn't. Yes, I did.
Okay. Where were you when you missed her recital?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
But you're a really good dad, right? And you're here at, I'm sorry, you're a really good dad, correct?
I'm a great dad.
You're a great dad. And you chose to not go to your daughter's recital to travel across state lines to go 15-year-old. That's what a good dad does, correct?
Objection, argumentative.
Judge, this is cross-examination. I think it's a fair question.
Sorry, that was argumentative. Sustained.
Thank you, Judge. Do you think a good father should choose their children above all other things in life?
I think that's a pretty broad question. I mean, we can dialogue on it if you'd like.
Okay. Have you looked up stalking addictions on the internet and feel that you have, I'm sorry, let me just make that two questions. Have you looked up that you have a stalking addiction on the internet?
No.
You never have?
I have absolutely no recollection of ever looking up a stalking addiction for myself on the internet.
Okay. I'm going to show you what's been marked as P10. And Judge, I'm going to move to introduce P10, which is the current indictment that Mr. Whitaker is under.
Your Honor, before counsel shows it on the screen, the copy that I have, that counsel provided me, speaks of the file being sealed, under seal. And I'm concerned about, I don't know how we have it if the matter's under seal, but that's what the document recites. And I'm concerned about the publication of it in this procedure.
So I can tell the court exactly why we have it. It's not under seal. It was under seal when it was first indicted, and the prosecutor gave me the copy once the indictment was unsealed. However, the copy that he provided me still has that it is a sealed indictment, but it is not a sealed indictment. It has been unsealed after he was originally arraigned in court.
Does it have, I assume this is a no, it doesn't have any identifying information.
It has
any-
none.
Then I'm going to overrule Mr. Kazan's objection. What is this, Exhibit 10?
Yes, Your Honor.
10 is admitted.
Thank you. Just out of curiosity, Mr. Whitaker, has the U.S. government made you a plea offer in this case?
I'm not aware of it.
Okay, your attorney has not communicated to you any offer of what the U.S. government's willing to do in exchange for a plea of guilty?
I don't know if I'm supposed to testify on my communications with my attorney.
Your Honor, I will object on basis of attorney-client privilege.
Except for attorney-client privilege covers the communications that should be subject to privacy. What this U.S. government has conveyed to him as an offer to resolve the criminal charges is not subject to attorney-client information. There are discussions about it may be, but not the actual proposal.
But he's already answered that question. He said that he's not aware.
Yeah, I think it does invade the purview of the attorney-client privilege. And so, but a reminder to Mr. Whitaker, that's not an objection for me to overrule or sustain. It's a right of you to either enforce or waive. And it sounds like with Mr. Kazan, who's not that attorney, you're choosing to continue to say you do not want to waive your attorney-client communication privilege. Is that correct?
You're correct. I don't want to waive my attorney-client privilege, but I believe I already answered the question as well.
All right, there we go.
Thank you, Judge. And so the first count is enticement of a minor. From on or about April 4th, 2023, and continuing through on or about May 20th, 2023, in Mecklenburg County within the Western District of North Carolina, it goes on to say that you did a particular thing with regards to a minor victim, and that you, using a facility and means of interstate and foreign commerce, attempted to and did knowingly persuade, induce, and entice an individual under the age of 18, that is a minor victim, to engage in sexual activity for which the person can be charged with a criminal offense. So did you first reach contact with this victim on April 4th, 2023?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Okay. And so you actually stayed in contact with her and were enticing her to travel to meet you in North Carolina from April 4th, 2023 until the date of May 20th, 2023. Is that correct?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
How many other minors were you trying to entice at the same time to meet you?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Okay. So there were more than just this one victim that you were seeking to entice at this time, isn't that correct?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Oh, by the way, what's the sentence range to your understanding on the count one?
I don't have an understanding of any ranges at this time.
You're not aware that the minimum sentence is 10 years and the maximum is life?
We haven't spent time on that. We're, to waive my conversation with my attorney, we've been focused on the case versus talking about any penalties.
All right. So from on or about April 4th, 2023 through on or about May 20th, 23, same thing in North Carolina, you then attempted to and did employ, use, persuade, induce, and entice a minor that is a minor victim to engage in any sexually explicit conduct for the purpose of producing any visual depiction of such conduct using materials that have been mailed, shipped, or transported in and affecting interstate and foreign commerce by any means, including computer, and the visual depiction was transported and transmitted using any means and facility of interstate and foreign commerce. So were you having her send you sexually explicit pictures starting on April 4th?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
And in fact, you were using Snapchat to receive these basically pornography pictures from her, isn't that correct?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
How many other girls were you receiving? I'm sorry, let me rephrase that. How many other minor children were you receiving naked pictures from during this time period from April 4th through May 20th?
Objection. So assumes facts, not in evidence.
Judge, I didn't assume anything. I asked him how many.
Overruled.
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Is this the only child that you have sodomized?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Have you had sex with more than one child under the age of 18?
Under
Your
advice
Honor,
of
I'm going
counsel,
to repeat my objection to the extent that the question assumes that the initial act she's asking about did in fact happen, and then she's going on to ask about more. That's assuming facts, not in evidence. So that's my objection.
Well, in terms of the way that last question was phrased, I will sustain that objection and ask Ms. Locke to rephrase the question.
Yes, Your Honor. How many girls under the age of 18 have you had sex with?
under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
How many boys under the age of 18 have you had sex with?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
And count 3, which is the last charge, relates to you traveling through interstate commerce for the purpose of engaging in any illicit sexual conduct. How many times have you traveled to a different state to have sex with a minor?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Have you traveled to any other states? I'm sorry. I'll strike that. Have you made arrangements to meet more than one individual across state lines for the purposes of engaging in sexual activities?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Okay. And have you made arrangements on more than one occasion to meet minor children across state lines to engage in sexual activity?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Okay. Why did you place a camera outside my client's window without her consent or knowledge?
Could you be more specific?
Okay. You placed a camera outside her window, correct?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Okay. And that's because what you did was by placing that camera there without her knowledge was illegal, correct?
Under advice of counsel.
I'm going to object to that one on the basis that it assumes facts, not in evidence.
Judge, the problem I have with some of these objections, it assumes facts not in evidence, is the court, when he pleads the Fifth, is allowed to construe those against him. So for my purposes, those are now facts and evidence because he's pled the Fifth.
Right. I think though, if I'm being fair about what pleading the Fifth means, you are correct that a civil court can draw a negative inference. It still doesn't allow you to assume facts not in evidence though, because you don't know if I've drawn it or not. And
Okay.
so you still have to ask a question that does not assume facts not in evidence. So
Yes, Your Honor.
I'm going to sustain that objection and continue forward.
Thank you. I'm going to show you what's already been introduced into evidence as P35. This is the camera that you placed outside my client's bedroom window. Is that right?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Okay. And you actually sent Miss Whitaker a text message shortly after she had discovered what you had done. Do you recall sending that text message?
I mean, is that two questions? Could you clarify?
Do you recall sending her a text message right after she found out about you recording her surreptitiously?
I mean,
Your Honor, I'm going to object to that one because although there are some facts and evidence, the question asks my client to admit to the viewpoint that Ms. Whitaker recited when she talked about this camera. So,
But here's the other thing. It's a very fine line, and Ms. Locke doesn't have a lot of time. But I'm going to overrule that objection because it's still cross, and you can still ask cross-examination type of questions. And so that question was okay. We might need to go back and re-ask it, though, because we've had so much talk over it now that well, Mr. Whitaker might be taking the fifth anyway, but I think it's still fair for you to go back and re-ask the question, Ms. Locke.
Well, I'm going to pull up the exhibit to make it easier. I'm going to show you what's been marked as and actually introduced as P41. You recognize this text message that you sent to Ms. Whitaker. Is that right?
yes, ma'am.
Okay. And so you admit you I feel horrible for the way my actions have hurt you. I understand the paranoia, but there's nothing else. The past 3 weeks, this punishment finally broke me. I did an unthinkable, insane act out of insecurity and loneliness. So what was that unthinkable, insane act that you were referring to?
Under advice of counsel, I respectfully decline to answer pursuant to my Fifth Amendment right against self-incrimination.
Okay, so what insecurity and loneliness that you were going through I'm sorry, let me rephrase. What insecurities were you having at that particular time that you thought monitoring your wife was appropriate?
I feel like that's a little leading. I can answer questions about insecurities and loneliness, but I don't know if I agree with the second part of the question. I don't know if you want to rephrase it, or if you want me to just answer about insecurities and loneliness, or something about my wife.
Judge, I'm object as non-responsive.
Sustained as to non-responsive. And Mr. Whitaker, Ms. Locke can lead if she wants to. She's basically on calling you as a hostile direct witness, which is similar to cross-examination. And she has the ability to ask leading questions.
All right, if you want to ask it again, I think I can answer it.
I'll just move on. Mr. Whitaker, have you told the children where you are currently?
I haven't had a chance to. I've barely been given any time to speak with them since my arrest.
Since your arrest in June?
No, in my arrest in September.
Okay, but you had opportunities to talk to the children during your supervised visitations, correct?
Yes.
Okay, and so you've had plenty of opportunities to actually talk to the children to tell them that you may be away for a while, right?
But it wasn't something that we spent time on, and I didn't. At this point, I don't know that that's the truth.
Okay, well, how old is your youngest?
Julie's 3.
Okay, how old was she when you were arrested?
1.5.
1.5. So she has no memories of you outside of you basically being incarcerated and a few visits that you had after you bonded out in February, right?
I disagree.
Okay, so we're clear. You're incarcerated from June 1st until end of February, correct?
Correct.
And you were out from basically March until end of September when you were rearrested in October, correct?
Yes, ma'am.
That's March, April, May, June, July, August, September. You set 7 months, and you had supervised visitations once per month when you came into town and there were several days in a row, but correct?
Yes, ma'am.
All right. And during those opportunities, you never once sat down your kids and said, "Hey, I'm sorry, I'm not with you all the time," right?
I disagree.
Okay. And did you tell them why you were not going to be around them all the time?
No.
Okay. Have you apologized to Miss Whitaker for the position you've put the family in?
Yes, I am.
Okay. And tell me this. Do you think that it's appropriate for the children to know the charges that you've been accused of?
Not at this age, no.
Okay. But yet you think it's appropriate for them to come see you behind glass. Is that right?
Actually, there's no glass, first of all, in the institutions that I'm being housed in and I expect to be housed in. And secondly, I absolutely believe it's in their best interest for us to be able to have visits in person.
Okay. And you believe that you should disrupt their schedules at least once a month for them to fly down to whatever facility you're in to come see you. Is that right?
That is not our request.
That's not the request your attorney made in his opening statements?
That's not the request.
What is the request then?
The request was for the children to be released to a blood relative so that they can spend time with my family because When I bonded out, Miss Whitaker completely alienated their grandmother from them and their aunt and uncle, other than the supervised visitations that I had where they were able to spend time with them. And furthermore, during the times where they're with their blood relatives from my side of the family, I would expect that we would potentially, depending on where I'm housed at, if I am incarcerated, potentially have visits 2 times a year if it's not close. And if I'm housed as close to Bastrop, yes, potentially once a month or once a quarter.
Okay. And so do you have any idea? I mean, do you really know how long you're going to be away for?
I have no idea right now.
How does Weston explain to his baseball buddies that, hey, I gotta go visit my dad in jail?
Well, I think that'll be a conversation if we get to it. The best way to explain it if it comes up.
And you understand if you're convicted, you'll be a registered sex offender for life, correct?
I don't have any understanding of the outcomes at this point.
I just want to make sure we're clear. You're telling this court under oath that you don't understand that if you are convicted of being a child, that you won't be labeled a sex offender for the rest of your life. That's what you're telling this court under oath?
Your Honor, I am object to on the basis of facts, not in evidence. That's not the indictment presently before. Well, it's not the indictment that's presently alleging.
Well, it's also calling for a legal conclusion. I mean, I think we can move on. I'm going to sustain an objection to that question.
Thank you, Judge.
Go ahead.
All right. So, Mr. Whitaker, how do you explain to your daughters what you've been alleged to have done?
I think when the time comes, we'll sit down and have a conversation about it.
Don't you think your children should try and carry on as normal of a life as possible without the stigma that comes attached with what you've been charged with?
Ms. Locke, I believe that we both have one mother and one father, for better or for worse. And I am an extremely positive force in their lives, and I want to continue to be. And I absolutely don't want to disrupt their lives, but I do want to be part of their lives and feel that I can provide them with love, support, whether I'm close to them or far away.
So how can you be involved in their school activities?
Well, that's a good question. We spend time on our video calls right now doing math, drawing, just as reading books, just as if I was there with them.
Mr. Whitaker, isn't it true this is just more about what you want as opposed to what's best for the kids? It is you that wants to see the children. You're not putting their needs first.
I completely disagree with that. It would be easy for me to spend my time here not thinking about the children because those are the hardest days. But the time with the children, and the reason I fight for their time as it continually gets canceled, and their video calls get removed without any kind of makeup, because they tell me it's important to them, and
they object as to non-responsive at this point.
Sustained.
Okay. And Mr. Whitaker, how do you plan on supporting the children while you are incarcerated?
Well, there's multiple levels of support. The emotional support I'll provide to them is via video calls and in-person visits if I'm incarcerated for a period of time. During those calls, we're just going to continue to have fun, happy times, continue to do schoolwork and read.
How are you going to financially support them?
And then financially, in my proposal, we propose that I'll receive 50% of the future payout from the sale of my business, which will be $12,500 a month. What I've determined, Ms. Locke, is taxes on that will be about $1,875 a month. I've fully the entire time suggested that I will pay full guideline child support of around $2,700. If I also pay their medical expenses, which is around $400 a month, that's $3,100 a month.
All right, so you think it'd be appropriate for the court to order you?
Do you want me to finish?
No, because at this point it's non-responsive.
Your Honor,
Yeah, I'm gonna stop it. Let's ask another question.
Thank you.
Yes, go ahead.
So you think you should be ordered to pay $2,700 a month? Is that correct? In child support?
Yeah, I think that's fair.
Okay, and you think you should be ordered to pay the $400 a month in medical health insurance reimbursement? Is that correct?
In my proposal, we said if I'm awarded 45% of the estate, that yes, that does make sense.
And how do you plan? Well, strike that. All right. So you think your financial obligation should at least be $3,100 per month to Miss Whitaker for the children. Is that right?
If we're awarded 45% of the estate, yes, ma'am.
Okay. And if you're not awarded 45% of the estate, what do you think your financial obligation to the children should be?
Well, that's going to depend on how that award changes.
Okay. So what do you think the award should be if the court does a 70-30 split like Miss Whitaker is asking?
I haven't had a chance to do the math on that.
Did you have any job while you were out on bond in North Carolina?
Yes, ma'am.
And what job did you have?
I worked multiple jobs. I did landscaping. I did handyman work. I picked up, there was a hailstorm that came through South Carolina, and I picked up work as roofing sales. I did volunteer work at a couple of events, and then I was in the process of meeting with home builders. Had been on multiple excursions with them to become a gopher for them.
Are you
And
aware
then
that
finally, I did have one more job. I mean, whether it was a job or not, I was buying and selling trading cards, and I had made around $5,000 in September doing so.
are you aware that we've not received any income documents from you during this period of time?
I'm aware that you've never requested them.
You're you know you received requests for production from us, correct?
And I provided at every opportunity your request for production.
And you would agree that you have not supplemented any of your income information from while you were released from custody in February of 2024, correct?
I haven't received a request to supplement my income.
You understand you're on under continual duty to supplement your discovery responses, correct?
I was not made aware that I needed to supplement my income.
How much money did you make during this period of time while you were released from custody?
I don't have it written down. Maybe I can come back to it later if you want. Over lunch, I can add it up.
Mr. Whitaker, you're a financial advisor, correct?
No, right now I'm unemployed.
I understand that, but that was your stock and trade that you sold your business for, correct?
Yes, ma'am.
So you understand finances and money really well, right?
Yeah.
And in fact, your attorney has said that you should receive a good chunk of the estate because you can invest it so well to make money, right?
Investing is my trade. Yes, ma'am.
Okay. And so then why is it you can't tell the court a reasonable amount of what you actually earned while you were out on bond?
I don't have an accounting of it, but like I said, I can work to estimate it for you if you give me some time.
I want to be clear, Miss Locke, that you have 30 minutes left and you got to call your expert later. So I just want to make sure you know your time because that was the rules of the game from yesterday.
I understand at this time I'm going to pass and reserve the remainder of my time for additional recross and then shortly Ms. Desai.
Thank you. Mr. Kazin, how do you want to do this? Are you going to call him now? Or are we going to, I mean, it doesn't really matter because I told Miss Locke, just like I told you, we can call witnesses out of order. So if for some reason you don't have any questions now and then you turn to your case in chief, it won't really change things very much, but I'll leave it up to you how you want to do it.
What I'd ask for is 30 seconds for me to get my legal assistant to tell me when our first up is, because I don't know.
When your first what is?
First witness up is pre-scheduled.
Oh, okay.
And because we may not have somebody till 10, we may not have somebody till 10:30.
Sure. Well, why don't we just take a quick 5-minute break then? You get
5-minute
break. All right.
Yes, ma'am. Thank you.
It looks like we have a witness in the waiting room. That's what it looks like. There's a Cicely Nasso.
That's correct, Your Honor. That's who we got to call this time.
Okay, well, let's go back on the record because I know there was some witness disputes between y'all. So let's say on the record what I just said off the record, which is there is a Cicely Nasso in the waiting room. I assume that is a witness. And it is, well, so I assume by doing this, you do not want to question Mr. Whitaker right now.
I would prefer to get on this witness if that makes
Okay. All right. So all right, that works for me because you can either does it work for you, Miss Locke? Is that all right with you? Because we're jumping around now and it's not entirely clear. You can ask Mr. Kazin to be clear about what we're doing, but I'm just going to allow him to call Miss Nasso out of order, and then we'll come back to Mr. Whitaker later.
I'm fine with that because I have to reserve my time for Ms. Desai, who can't be available till the afternoon, and I'm flexible with however the court wants to do it. It's fine with me.
Just
All
for
right, we're not going to
housekeeping,
worry about form. We're just going to go forward and do it this way.
if I may, just to sort of, so we're coordinating a little bit, Ms. Locke, what time do you have Ms. Desai? Because I've also got folks.
So I have her available at a couple different times. I think one is between 1 and 1:30, and then I've got 2 and 3. I think the times I have, so I can wait until 2 to 3 because she's
Okay.
not going to be a long witness.
I have a one that I cannot move, who's only given me 1 o'clock. So if we
Okay,
can
that's
keep
fine.
that- Yes.
Okay, well, let's do that. All right, that sounds good. I'm hearing no objection from Ms. Locke about Ms. Nasso, so I don't think that was one of the problem witnesses from her point of view. So I'm going to bring Ms. Nasso into the Zoom room now.
Thank you, Judge. Ms. Nasso, you and I spoke for the very first time just last night. Is that correct?
Yes.
We're on short time here, so I'm just going to sort of speed along through some of the basics. Is it true that you're a supervisor that has supervised some of the visits between Mr. Whitaker and his children?
That's correct.
Okay. How many of those visits do you think you've supervised?
1, 2, 3, 4, 5, 6, 7, 8, a little bit over 10, maybe 11 or 12. 12, I think.
And you or your company has provided all of those supervision reports to both sides. Is that generally how this is done?
That's not my purview. I assume if they've requested them, but that's not part of my role.
Do you personally write them up?
Yes.
Okay, so you have written up visits. If they're in reports that are written up, that's you writing them up. Is that fair?
Yes.
Okay. What is the name of the company you work for?
Angels Monitoring.
Okay. Your Honor, at this time, I would like to offer as exhibits respondents 67 through 82 as supervision reports.
I don't have any objections, Judge.
67 through 82 are hereby admitted.
Now, so I want to show you some of the supervision reports. I know that some of these are not going to be yours, but I nonetheless want to ask you if you, in your capacity working for Angels, do you ever have occasion to read other people's reports?
I have not.
Okay. I'll skip some of these. I can tell this one that's on the screen. This is Respondents Exhibit 67 is not one that you drafted. Is that correct?
No, I did not draft that report.
All right. When is the first, if you know, when is the first report that you did draft?
June 27th, 2024.
All right. I'm showing you what's labeled and admitted as Respondents Exhibit number 70. Is this one that you drafted, ma'am?
Yes.
Okay. In general, how would you describe the relationship that you observed between Mr. Whitaker and the children?
In general, they had positive interactions. Mr. Whitaker seems to care quite a bit about his children, and they, displayed an appropriate amount of attachment to him.
Okay. I'm showing you on the screen all these comments where my cursor is running. These are all drafted by you. Is that correct?
Yes.
And so you wrote Weston showed excitement to see his dad, and they went and hugged and laughed. Is that correct?
Is that from the 27th? Oh, yes.
Down below, I've highlighted the words. They played Pokemon on Mr. Whitaker's phone, and conversation focused on the game. They were comfortable and affectionate with each other. You wrote that?
Yes.
This Pokemon thing, is it a game that came up quite a bit in your observation?
I think in just about every visit.
It's a game that the father and son played together?
Primarily, I mean, yes, I think Rusty oversaw it. Most of the time, I think Weston was playing on his own. But they did, I mean, especially if they were in a visit one-on-one, they would play together more often.
Now, it says down here at the bottom, Weston didn't want the visit to end. Was he the only child on this visit?
On June 27th, yes.
The final sentence says he and Mr. Whitaker expressed love for each other and hugged. Was that common in your view?
Yes.
I'm going to show you R71 and ask if it's one of yours. This is the next day, apparently, June 28th.
Mm-hmm.
And it apparently is with you and Mr. Whitaker and all three children. Would that be correct?
Yes.
Let's get to the text of it. All three children were eager to see their father. That's what you wrote?
Yes.
Overall, would you describe what your observation was between father and children as positive and healthy?
The interaction, like interactions between the two of them or between parent and child? Yes.
And to be fair, it wasn't always just Weston too. The girls had a pretty affectionate relationship with their father. Would that be true, ma'am?
Yes.
Did they always exchange hugs and kisses at the end of the visits?
Yes.
Did you view that as a positive thing between parent and child?
Yes.
I'm going to show you what has previously been marked as Respondents Exhibit number 72. And this is, again, the next day. This is June 29th. Is this one of yours?
Yes.
It seems like there's a regular and common occurrence that when the children first see their father and the father first sees the children, there's a warm greeting and a hug, and everybody's excited to see each other. Is that true or not true?
Yes, that is true.
At the end of this particular visit, it appears Desi had some reluctance to want to leave. Is that correct?
According to my note, yes.
What is this bit about one more airplane ride? What is that, if you could tell the court?
He was holding her and kind of zooming her around like an airplane.
How many times did you observe that kind of thing?
Multiple times. On multiple occasions.
Several of the different supervised visits?
Yes.
And what about on June 30th? Was this also one of yours?
Yes.
If you know from your notes, how many times in a row or how many days back to back did the children see their father in this period in late June?
4 days in a row.
Would this have been the last of those?
June 30th. Yes.
Okay. Indicates, I believe, it says here Grammy helped with lunch. Would that be Mr. Whitaker's mom?
Yes.
I'm going to show you one in late July. It appears this one, at least according to this note here, says July 26th. And it also appears that it was just Weston. Is that part of your recollection?
Yes.
And you drafted this report?
Yes.
For the court's knowledge, who is indicated by RP?
The residential parent.
In this case, it'd be the mother of the children.
Yes.
So if I'm interpreting this initial correctly, Weston was comfortable when mom took off and he showed excitement to see his father.
That's correct.
So aside from playing Pokemon together, what kinds of activities did the children usually engage in with their father?
Let's see, on the very first visit, Weston and Rusty played baseball at a t-ball field. They went to an indoor golfing range a couple times. It was like a video indoor golfing thing. They went to Main Event frequently. Main Event is an indoor arcade and restaurant. They did that quite a few times. They also they had a spa day, a princess spa day. They went to Target on a shopping spree. Went out to dinner a couple different places. Went to a bookstore.
Showing you the next supervision report, which is for our purposes labeled Respondents Exhibit number 75. This one apparently was also in late July and apparently was with all three children. Would that be your recollection, ma'am?
According to my note, yes.
And again, all three children were very happy to see their father, were they not?
Yes.
This phrase that appears in the first line, pretended each child's hug knocked him over. Can you kind of explain what that means?
Sure. He's sort of crouched down onto their level, and the child would run at him and sort of pretend to knock him over onto the floor.
Did you see this just the one time or several times?
Multiple times.
And how did you regard that behavior? Was that just parent and child sort of horsing around or showing affection? How did you regard it?
I regarded it as like totally normal between parent and child, but sometimes inappropriate in the setting.
Just because of how sort of roughhousing it was, perhaps?
Yeah, just because of social propriety.
But not as between parent and child, but more the location.
Correct.
I see.
Correct. I didn't interpret it to be anything inappropriate between parent and child. More of a poor decision to do it when and where it happened sometimes, but not as inappropriate between parent and child.
Would that have been just because of small proximity to other people and other things?
Yes.
Okay. And once again, we see this comment about an airplane. Is that the same airplane behavior that we saw in the other report?
Yes.
Now, I'm going to show you what's been marked as Respondents Exhibit 76. This one is July 28th. Did you supervise on that occasion?
I did.
Okay, and all the children were there?
Yes.
On that next occasion, or the one we're talking about now, the kids again were excited to see their father?
Yes.
Did he always, or did he come with appropriate things for them? I mean, I don't want to put words in your mouth, so I'll just leave it at that. Did he come with appropriate things for the kids?
He came with an abundance of toys, gifts.
Toys, games, food sometimes.
Yes.
Made sure that they had things they could do during their time together.
Yes.
It's my understanding that Weston was not able to stay for all of this visit. Is that correct? Do you know
correct.
anything about that?
Yep. He had to leave for camp at approximately 11 o'clock, and that was prearranged.
The next one is dated the next day, July 29 of 2024. Were you the supervisor on this occasion?
Yes.
Looks like Weston was not there. Is that correct?
Judge, I've let it go for a little bit, but he's continually leading the witness that he's supposed to be directing, so I object to leading.
I can do it the other way, Judge. I'm just trying to speed along.
Yeah,
Ma'am?
I'm gonna overrule that. I'm gonna let you kind of lead her for if it gets into disputed fact issues, Ms. Locke, come back to it. But for now, I just want to move things as well as we can. So
Understood,
go
Judge.
ahead. All right, go ahead, Mr. Kazin.
So, ma'am, was Weston present on this occasion?
No.
How long have you been a supervisor, if you don't mind me asking, ma'am?
I've been with Angels Monitoring for 2 years.
You have another occupation, do you not?
Yeah, I'm a high school English teacher.
Do you feel, well, I don't want to put words in your mouth, but are you careful to draft these documents for accuracy as much as possible?
As an English teacher, I try to draft everything as carefully as possible.
I appreciate that.
Doesn't mean I don't find a mistake. Remember, we found one on the phone together last night.
A typo, right?
Typo, yeah.
Seems to indicate that Mr. Whitaker also was good with the children insofar as giving them direction if they needed it. Would that be fair, ma'am?
Can you ask that in a more...
Sure.
I don't-
Well, I'm talking about this comment up here. It says VP set appropriate boundaries when one of the girls hit or didn't follow instructions. I'm not sure how to read that. What got hit?
when one of them hit each other.
I see. And on this occasion, were the children sad to leave their father?
According to my note, yes.
Now, what's on the screen now is Respondent's Exhibit number 78, which is also a report, but it's not one that you created. Is that correct?
No, I did not create that report.
All right, but the name at the top of the document, that's the monitoring and supervising firm that you, or the company that you work for, is that correct?
Yes.
Kinds of things, when you see the children get upset, what would they usually be upset about?
Is there a particular date that you have a question about?
Not really. I just want to ask in general, just a few wrap-up impression sort of questions in general, because you've supervised now a number of these, and what I'm trying to ask you. Oh, by the way, before I move on, have we gone through all of the supervision reports that you drafted?
No.
When was the next one that you drafted, ma'am?
August 23rd.
All right. So this document was drafted by you. It's marked and admitted as Respondent's Exhibit 79. Is this the report from that day?
Yes.
It starts out only mentioning Desi. Was Desi the only child at this visit?
Yes.
This refrain I've seen a couple of times. The one that I'm pointing to right now, it's indicated in more than one of your reports. Is that fair, ma'am?
The best daughter and best daddy ever?
Yes, ma'am.
Yes. I heard that more than once.
That seems kind of like a routine that Mr. Whitaker goes through with the kids, or what would you call it?
I would say that I heard it on multiple occasions. I can't comment on whether that's a routine otherwise.
This comment up here that I'm pointing to now talks about changing a game into a math game, a learning issue. Is this the only occasion that you saw Mr. Whitaker turn a fun game into an educational game?
To my recollection, if there's a point on another report where we could look at a specific example, I could characterize it.
Sure. I'm not sure that there is. I just thought I'd ask if you recall anything else.
Okay.
Now, is this the last report you drafted, or are there yet more that we haven't covered?
There are more.
Okay, what was the next one you particularly drafted?
August 25th.
This was at a hotel room, ma'am?
Yeah, that's where it started.
Was it in close proximity to the main event where they went?
Yes, it was next door, located in the same parking lot.
So not, so in addition to going to the main event, it looks like they did some activities at the hotel. Is that correct?
Yes.
They went to the pool.
We went to the pool. Had a light dinner. And as you've highlighted there, just some games. Child parent games.
You've got the words hallway hugs in quotations. Why is that?
That term developed and Rusty used that term with the children.
Here we have the knock daddy over hugs again. Do you see that, ma'am?
Yes.
Okay. Now, when was the next visit that you supervised?
September 21st.
I'm not sure I have that one. Why don't you, do you have your, well, I'll tell you what, do you have a remembrance of what happened on September 21st?
Yeah, I have all my notes with me. There are two others that I supervised on September 21st and September 22nd.
Why don't you just tell the court in general what happened on those occasions?
Sure. September 21st was a 4-hour visit. All 3 children were present. It started at the hotel room and they went to the arcade main event.
All right. And the other one was what?
The other one was September 22nd. It was a 3.5-hour visit with all 3 children, also located at the hotel room.
In general, did you, was the interaction between Mr. Whitaker and his children overall positive? I mean, I'm taking the whole ball of wax together.
Yes.
I pass the witness.
Real briefly, you actually have expressed some concerns to Ms. Whitaker regarding some of Mr. Whitaker's behavior at visitations. Is that right?
There are a couple things that I had concerns about.
Okay, and what specifically did you have concerns about?
As I mentioned a moment ago, I just found that while the hallway hugs and the knock daddy over routine is healthy and normal between parent and child, I didn't think it was appropriate in certain public contexts. For example,
I'm sorry. And for example, did something happen at the main event that was inappropriate in your particular mind?
I mean, he did encourage that at main event, like in the main walkway, as well as in the restaurant area near other diners.
Okay.
And I think that was appropriate judgment.
And he would actually lay on the floor in main event and have the children essentially dogpile him at the main event in the middle of the floor. Is that right?
Yeah, I remember seeing that.
Okay. And did you have concerns about him expecting you to actually babysit the children while he did things at supervised visitations?
You'd have to ask me about a specific occasion. That would
Sure.
be.
Was there a particular occasion where he misplaced one of the children or did not know where they were?
Yes.
Okay. And what was that particular incident?
We were at main event, and Desi had a favorite game that she would go to. It was like a virtual reality game where she had to, sit in the machine and put on a headset, and she loved that game. But it took quite a while. And so I think there was at least one occasion where he went to play games in another part of main event and left her there. And I remember, I think there was one time where she got off and went looking for him and then he had come back, or, they couldn't find each other.
Okay. And were you with Desi at that time?
I was not.
Okay. And was anyone watching Desi at that time, to the best of your knowledge?
No.
Okay. Was that one of the incidences where you felt that he thought he was expecting you to babysit the children while he went off and did other things with some of the other children?
I mean, my job is to stay with him. So although it made me uncomfortable, I followed him and would always try to keep, as a mother, I would always try to have an awareness of where a child would be on those events, but I had to stay with Rusty and the other kids.
Okay. And was there ever a time where Mr. Whitaker tried to use the bathroom alone with one of the children?
I don't know about try.
Okay, let me rephrase. Was there a bathroom incident that raised concerns?
Yes.
Okay, can you tell the court about that?
Yeah. I think it was, let's see, August. So what precipitated depending on which one you're referring to, we were at dinner one night at Dairy Queen, and we were at the table, the kids had food, everything was sort of spread out, and one of the girls needed to use the restroom, and it just sort of happened, as I recall. I mean, it's really sometimes difficult when you're in these public settings and there's a lot of moving parts. One of the girls had to use the restroom, I think. Golly, what day was that? I want to go look at it. And so he did take her to the bathroom. I didn't think about it at the time because of everything going on. And so I did take responsibility for that. It was a short bathroom break.
But one of the issues was in the agreement that Mr. Whitaker signed for supervised visitation indicates that he's not allowed to do that, right?
I haven't seen their signed order.
Okay, is that part of, okay, so let me ask you this. How did Mr. Whitaker respond when you had expressed concerns to him about taking the child to the bathroom by herself?
Well, I think the incident that you're referring to happened at the next visit, which may have been the following month. I sort of proactively brought it up and said, hey, this happened last time. That was my bad. And moving forward, we can't let that happen again.
And how did he respond to that?
He got really upset really quickly, and just sort of wanted to go over my head and call Amy Burkholder, the owner of the company, to discuss it.
Okay. Have you ever expressed concerns to Miss Whitaker that you believe that Mr. Whitaker was monitoring her somehow?
Have I expressed concerns to her?
To Miss Whitaker?
I mean, it seemed weird sometimes that he knew things.
Can you give the court an example?
I knew you were going to ask that.
Would it help you if I talked about the incident where it related to requesting copies of the reports and if Miss Whitaker was being charged for them?
Yes, as a matter of fact, you're right.
Okay, so tell the court what happened with that.
I'm sorry, I don't recollect. That would be a good question for Ms. Burkholder.
Okay. Do you recall if Miss Whitaker had asked you for copies of the report through an email? Do you recall receiving or seeing an email regarding that?
Again, that would be an Amy question.
Okay, then I'll wait for Amy. I pass the witness.
I don't have anything further. Give me just a second to check my notes before I say that. Yes, Miss. Isn't it true that on the occasion where you were suggesting that Mr. Whitaker was separated from Desi at the main event, the period of time we're talking about is like 1 minute, isn't it?
No, it would be longer than that.
It was relatively short, though. Would you agree?
I'm not going to say if it was short or not. That depends on who's who's answering. I'd say it was probably 5 minutes.
And you know, yesterday I did ask you about this incident about Mr. Whitaker, and you say he was upset to be to discuss the rules about taking children to the bathroom. And you know, I asked you last night, and I'll ask you today, since we're in court. There's a version of that that's has creepy intent, and then there's a version that's just him trying to be a parent.
Judge, I'm going to object to leading.
Well, I'm just trying to orient the witness as to the conversation we had, Your Honor.
Okay, ask it again. I'm sorry. Ask the question.
Sure.
That was a lot. Go ahead.
I'll try to streamline the question. Ma'am, was there anything inappropriate about Mr. Whitaker's, you know, frustration that he couldn't parent his child the way he normally used to?
Was there anything inappropriate about that? If you are referring to whether I picked up on there being any sort of lascivious or...
Judge, I'm going to object this to non-responsive.
She can answer the question. She had a thought about it. We just interrupted her in the middle of it. So
Sorry.
if you
Sorry.
go
She's-
ahead, Ms. Nasso.
Yeah, I did not detect anything lascivious or inappropriate in a sexual way.
Okay. Did the frustration, as you perceived it, have anything to do with the father not being able to take care of their child as they normally would in a bathroom situation?
I'm going to object to leading.
That's fine. We can move on, Your Honor. I don't have any further questions.
All right. Thank you. Anything else from you, Ms. Locke?
No, Judge.
All right. Then at this point, Ms. Nasso, you are excused as a witness and you are free to go.
Okay, thank you for working with my schedule, Your Honor.
Yes. Thank you.
Bye-bye.
I'm going to remove you from the Zoom.
Your Honor, is there anybody else in the waiting room?
Dusty W is in the waiting room.
If it's all right with counsel and the court, I'd like to call Dusty Whitaker.
At this point, I'd really prefer we resume with Mr. Whitaker, because I think that was the order. We had a professional witness that needed to be taken out of order. That's fine, but his brother, in my opinion, can wait. He's not even employed.
Well, that's a question then for, I think your witness isn't here yet. And we come back to Mr. Kazin, who is either going to take his witness now or reserve his witness for his case in chief. He can do either one. And he has never made that decision. So what would you prefer to do, Mr. Kazin? That's as to Rusty Whitaker.
Right. So, Your Honor, I am only asking this because we had this incident yesterday. I mean, my belief under the law is that if I examine Mr. Whitaker now, it's in Ms. Locke's case in chief. I don't think that impairs my ability to recall him during my case in chief. The court feels differently about that, I know from yesterday. And so I'm just trying to clarify that if I proceed with him now, I'll have to finish with him now.
I think that what you have said is a trial judge's decision almost in total with how they wish to take evidence in their court. And basically that's all the issue is. And so my point is we're on efficiency. We're in an efficiency situation, and how the court wishes to take in evidence, unless it's rebuttal evidence, is calling witnesses at one time rather than calling them multiple times during the
Then in that event, I will wait until my case in chief to call Mr. Whitaker.
All right. And so then we come back to you, Ms. Locke. And the question is, do you rest? And the answer is no, because you wish to call your second witness later. And so I will allow you, I will not make you rest, but you're why we're in the position we're in because of what you just did. I'm not going to make you rest because your witness isn't available, and I already told you didn't have to. But now we go to Mr. Kazin. You are in your case in chief. And how would you like to call your witnesses?
like to call Dusty Whitaker first.
There we go. That's the only, we had to do that the long way, but the long way got us to the same place. I will call Mr. Whitaker. I'll bring him into the Zoom. You may proceed, Mr. Kazin.
Mr. Whitaker, you are Rusty Whitaker's brother, is that correct?
Yes.
And most of your you've got a wife and children. Would that be also correct, ma'am, sir?
Yes. A wife and two daughters, 13 and 11.
If you don't mind, give the court an understanding about historically how much time you and your wife and your children have spent around Rusty Whitaker, Lacey Whitaker, and their children.
Yeah, I guess, broadly speaking, like holidays, Thanksgiving, Christmas, whether it was on Christmas or, a later date and time, kind of coordinating around schedules, different birthday parties, activities, going to baseball games or coming to my children's like plays, just different activities kind of throughout the year for both sides of the family.
Okay. Is it the same now as it was how you just described it?
No, things, since we bailed Rusty out in February, we really haven't had a lot of contact with the like Weston, Desi, and Julie, other than during my brother's like supervised visits. We hosted here at our house for a lot of those supervised visits. Well, not a lot. I'd say some of the supervised visits we were hosting generally like one day a month over here at the house.
How old are your children?
I have two daughters, 13 and 11.
Okay. Are the cousins close at all?
I would say that they enjoy hanging out with each other. Obviously there's a little bit of an age gap there. So different likes and interests. But whenever they come over, my two daughters will definitely like interact. They would, like if Rusty was doing something with Desi or Julie, they might play like, Mario Kart on the Nintendo Switch with Weston, or, they would play something with, they would help, Desi or Julie color while my brother did something with Weston and kind of, I wouldn't say helped out, but just kind of played on the, who was available while my brother played with the children.
And when was the last time your children got to see their cousins?
It would have been at one of the visits. I don't recall if it was in September or August, but that would have been those would have been the last dates that we would have seen them.
So I've got a list of issues that I want to go through, but have you taken care of Rusty's three children in your household when either Lacey or Rusty were not there to be with them?
Yeah, no, yeah, we definitely have, over the years, whether it's, they go to the same, West went to the same elementary school, whether we would, pick one of them up or, have one, briefly here or there. And then while my brother was incarcerated, there was a couple occasions where, we had the children over here, whether it was like inviting Desi over just for a baking day, and we just baked like cupcakes and cookies and stuff, with Desi, on, kind of Christmas, which was held in January, kind of similar thing where, we had Julie and Desi here in the morning while Lacey and Weston, I believe, went to a funeral. They had other obligations. So Lacey dropped the two daughters off over here. They spent the night, here because our cousins from the Dallas area were also in town. So, we had kind of all eight of them kind of over here at the house that evening. So there have been, several occasions where, we've offered to help. We've either had them here or not. But the last occurrence of that would have been, prior to my brother being bailed out.
So just how many occasions, or can you even quantify how many occasions you've had one of the children, one or all of the children in your house, taking care of them for Lacey and Rusty, who were somewhere else?
I don't know that I'd definitely necessarily be able to quantify that.
I'd say an easier number to call. I mean, there was several occurrences, prior to my brother's incarceration, and I would say there's, 5 to 10 occasions. I don't know if 10's probably on the high side. Since his incarceration, where we've had, one or more of the children here.
Okay. So one of the things that your brother has requested in this proceeding is that you have the ability to pick up the children if he's incarcerated and either take the children to visit with your side of the family or take the children to visit him as the jailing system might allow. Are you willing to do that?
Yeah, absolutely. Whether it's, picking them up and flying them wherever it needs to be flown. We'd love to maintain a relationship, on this side, our other cousins, my sister and her children come down, to celebrate Christmas and sometimes, other events. I'd like all of us to go. Last summer we took a family vacation with my sister and her kids. We had invited, that Weston, Desi, and Julie could join us. We would love to have the kids, for events like that, so that they kind of all stay connected as they grow up.
Just so the court has a full understanding of your ability to take care of children, is there anything aside from merely having your own the court to know about?
Yeah, so me and my wife have both been certified foster parents. We are not currently certified foster parents. Over the years, we've had 7 children placed with us, and we've cared for multiple others through the respite care system, which is basically, in order to kind of babysit, overnight a foster parent, you have to be kind of a certified foster parent or, approved by the court. And so we provided that service to other foster parents where we would, babysit for a weekend or a week so that they could take a vacation, kind of, throughout the years. So yeah, we've been through all the foster care training, been through multiple trainings on, mental health, how to, treat children, how to interact with children, within, the confines of the, kind of what the state of Texas expects.
So let's talk about your brother as a parent to his children. Can you describe what kind of a dad he is to them?
Yeah, like he's playful. He gets down and meets the children where they're at. He's more than happy to get down and roll around on the floor with them. If Desi wants to paint his nails, or I've got 2 daughters. I've had bows and scrunchies and everything put in my hair. They'll try to get as much hair into a rubber band. Whether it's letting his daughters paint his fingernails. Going to spa day with them. Like just meeting them where they're at and making them smile, I would say is something that my brother does, quite well.
In your observation, does he devote enough time to them, or what's his work-life balance as far as that goes? Do you have an observation about that?
I mean, I would say I was always, for many years, I was jealous of his, ability to just go take the kids and go do stuff, because his job had more flexibility than mine. I can't speak to exactly like how much time he took off work, but I do know from conversations with him that he would, leave work and, and go get them or go pick them up or go do things with them. I know that, it was important for him to have, the kids with him doing things. I'm sure he did things on his own as well. So I don't know what his day-to-day schedule looked like, but definitely know the instances of him doing that.
Now, do you have any particular education or career training? What was your most recent occupation, sir?
Yeah, so I'm a certified public accountant. Most recent occupation was managing director for a private equity real estate company here in town, where we managed a little over $2 billion in contributions and $4 billion in assets that were kind of spread out over 21 different funds and about 1,000 different partner capital like statements divided up between those funds and investors.
Yeah. How long ago did you become a CPA?
I believe 2016.
So during this period, since you've appeared before the court in this proceeding before today, is that right?
That's correct.
Okay. And in what capacity did you do that?
Just kind of as my brother's like power of attorney.
You actually have a document that indicates you're his legal power of attorney?
Yeah, since December of last year. So
Okay.
December 2023.
And under what set of circumstances did it come to be that you have that?
Through my understanding is, disagreements between Rusty and Lacey while he was incarcerated, and kind of got to a point where my brother felt that his best interests, weren't always being, kind of followed, and that it was being used as a negotiation tactic against him. So in December, my brother decided to make me his power of attorney.
And in connection with being his power of attorney, what was it that you understood your task was to be?
Immediately when I took over in December, it was he had a business transaction that, while it had been like, the initial groundwork that laid, it hadn't gotten across the finish line. So it was to review the final, purchase sale agreement between Rusty Whitaker and Yuri McBride. So I worked with his lawyer that was drafting that in the opposing side to make sure that we got everything finalized, all the promissory notes finalized, and to assist Lacey and anything that needed to sell the house, to kind of get that across the finish line, and then kind of take over his affairs and manage his checking accounts, savings accounts, et cetera. Make sure that his life insurance was getting paid timely, and just kind of general affairs.
In general affairs, are we talking about management of financial accounts and personal accounts with companies and social media and things online as well?
Yeah, so I would say it was in a capacity. I want to be clear that it was in a capacity of like managing all those things, but not managing it in a fiduciary, like, as a CPA or financial advisor or anything like that. It was just managing it, kind of, I'd say it was as a role of a brother and a power of attorney role of, gaining access to those accounts and making sure like, to enact what my brother's wishes were of how he wanted to move money or what he needed to pay for. So
And
things like making sure his commissary, he had money in jail, making sure he had money for minutes, et cetera.
minutes, meaning phone minutes and such?
Phone minutes, yes, sir.
Okay. And are you still his power of attorney?
I am.
Okay. So if he needs something managed financially on the outside with regard to accounts that he's got at an institution, you would be the one to push buttons and get that done. Would that be fair?
That is correct.
Were you in that position when the final negotiations were consummated for the sale of the business?
Yes, I was. I'm the one. So even after my brother was bailed out, I'm the one that still continued on to finalize that business sale. One, just to keep everything fluid and moving. And so I signed the final purchase sale agreements as Rusty's power of attorney, even though he was no longer incarcerated, because I had the most information and the most up-to-date information and kind of was working with both legal sides.
With your training as a CPA, and you've worked in that capacity for various private companies, it sounds like, with your business knowledge, do you have any sense of whether or not there was a fair price garnered for the sale of the business?
Judge, I'm going to object. He's not been declared an expert. He has no expertise to discuss this. This is completely, he's a fact witness, not an expert on business valuations. And his opinion on it's not relevant.
Sustained. Mr. Rusty Whitaker can talk about it, but I don't think Mr. Dusty Whitaker can in his current capacity.
And so the only thing I'd observe there, Your Honor, is that Ms. Whitaker is neither a financial advisor nor designated as an expert either, and she commented all about it.
Correct. I think the parties can talk about things even if they're not designated. I don't think a non-designated fact witness can give this type of detailed testimony about valuation.
All right. I'll proceed, Your Honor. So Mr. Whitaker, was it was it easy or was it difficult to get control of the accounts that needed management as a power of attorney?
Yeah, so I received the power of attorney in December, and made requests to Lacey for kind of a password list, account list, and information to be able to gain those access. I needed his cell phone for two-factor authentication, and asked multiple times, and it was not until the early to mid part of January that I finally received all the information to be able to start gaining access to those accounts. And then once I kind of started to gain access, it proved to be very difficult, and not anything like it just like things were still linked to Lacey's phone, versus Rusty's phone. So I'd have to, text her to get her to give me the 6-digit code so I could log in. I felt like some passwords didn't work, so I tried to reset passwords, and those password emails would go to a Lacey email, so that once I got in, I kind of had to like change phone numbers, change email addresses. But even with the password list and everything, it took a period of time, and I wasn't exactly working on this 40 to 80 hours a week. So as I gained access, me and my brother would kind of go through some of them. We would have to I'd have to have him call me from the jail so that I could then call the institution so that he could be the one on the phone like talking them through. And so there was some difficulty like getting access to all the various accounts.
From your standpoint, your individual standpoint, did the difficulty you just now recited have anything to do with your brother's bonding out of jail?
Ultimately decided to bond him out of jail. Discussing with him, it was he'd worked as a sole proprietor. We didn't have all the information, kind of from his business from business transactions, business expenses, in order to be able to do reasonable tax estimates and everything. Had a conversation with my brother, was like, look, you would need to hire me full time to do your taxes and manage your affairs to get a hold of all of this. And this is proving to be quite difficult. And it's just time for you to be, bailed out of jail, and you need to come to get control of this in a reasonable and organized fashion.
Was Lacey Whitaker, Mr. Whitaker, your brother's power of attorney before you?
Yes.
Okay. And did that continue, or was it revoked at some point when you took over power of attorney?
It was revoked on the day that I received the power of attorney. You guys would know better than me, but I believe the date was December 13th. I don't have it in front of me.
Okay. Assuming that's right, do you know whether or not Ms. Whitaker continued to access the financial accounts?
Judge, I'm going to object this calls for speculation.
Your Honor,
Overrule.
I don't have direct evidence. I have conversations with my brother that there are instances
I'm
where
hearsay and speculation again, but hearsay for sure.
Sustained on hearsay. Yes.
Yep.
Sir, do you recall what the final sale price of the business was?
It was around a little bit over 1.8 million. I don't have it directly in front of me and haven't looked at it in a while, but should have been around 1.8 million. 1889 or something. I don't have it directly in front of me.
As Mr. Whitaker, as your brother's power of attorney, have you had access to his retirement account?
I have.
Okay. And have you obtained historical statements that would be necessary to look at what kinds of contributions were acquired when?
Into his retirement accounts?
Yes.
Yeah, yes. I've reviewed monthly, quarterly, and annual statements with my brother on all of his retirement accounts.
Okay. Have you obtained copies of his former payroll at his prior company that might indicate what kinds of contributions that he made with it through his former employer?
Yeah, so
Judge,
USAA.
I'm going to object I think he's trying to use him as an expert for tracing based on these questions, and I think this line of questioning is completely inappropriate for this witness to answer.
The question was, Your Honor, does he have access to those statements? Did Your Honor respond?
I thought I did. I'm going to overrule the objection for now. He can answer that question. He may not be able to answer the next question.
I'm not sure about anybody else, but I hadn't heard your response, but thank you, Your Honor. So do you have access to the statements that I just asked about, sir?
Yes, so I believe it was on September 30th, USAA emailed my brother's payroll statements to him, and I have accessed and downloaded those and provided them to legal counsel.
Thank you. So as it regards your brother's future and his relationship with his children, and more specifically, the children's relationship with your side of the family, is there anything else that you would want this court to know that about what you think is best for those children?
This is me just being, foster parent training. I know it's always best for the children to.
Judge, I'm
maintain
going to
a-
object. This is it far exceeds.
Correct. I think currently
Yeah.
I have to sustain the objection.
Okay.
Yeah.
I pass the witness, Your Honor.
Okay, thank you. Ms. Locke, let's go with you. I think what I'll do is you can cross. Remember, you don't have a whole lot of time.
I know.
And then we're going to take a break, and we'll probably go closer to noon rather than ending at 11:30 today. Oh, unless y'all don't have anybody else. I don't know what you have, but I see Lisa Whitaker in the waiting room, and my intention is to try to get through Lisa Whitaker, but I do think we need to take a break for Ms. Racanelli after you do your cross-examination here, Ms. Locke.
And it'll be short.
All right, go ahead.
All right, Mr. Whitaker, what other bank accounts does Mr. Whitaker have in North Carolina?
I'm not aware of any bank accounts in North Carolina.
Okay. And what is the bank account that he's deposited his income that he earned from February or March of 2024 through September of 2024 into?
It should have been his, there's two Wells Fargo's account. There's a business account and there's a personal checking account at Wells Fargo.
And that is the account where all of his income came in during that period of time?
I wouldn't be able to speak to that. I don't know what income he's earned.
Okay. Well, were you aware that he was working during this time doing roofing and various odd jobs?
I know that he was pursuing different career options of businesses that he could start. Outside of that, I don't know of any income that he earned other than through Whatnot, which is where he was selling trading cards.
And how much did he make on Whatnot?
I believe it's a little over $5,000, which you can see deposited into one of the Wells Fargo accounts.
Okay. You exchanged text messages with my client immediately after his arrest, isn't that correct?
Which arrest? Like in June of 2013?
Correct.
I'm assuming I'm sure once I got set up, it would have taken a couple days to, you're with your client. Yes, with Lacey. Yes, absolutely. Yep.
Okay. And you recognize these text messages, correct?
Yep.
All right, Judge, I move to introduce P50. I haven't heard anything, so I don't.
Yeah, I don't.
He's looking at them, I think.
Yeah,
I can scan down.
I'm trying to figure out the relevance, but I don't think I have an objection, Your Honor.
Then 50, I think you said it's 50, right?
Yes, Your
50
Honor.
is admitted. 50 is admitted.
Okay. When you were sending these text messages to my client, you believe that he was in fact guilty of the offense he was charged with. Is that right?
I was acting on information that was given to me by your client, of information that was told to her by the FBI. So I was not acting on any innocent or guilt other than the fact, if the facts were true that the FBI was telling her, that's what I was acting off of.
Okay. And have you reviewed his bank records, correct?
I have not reviewed his bank records. I have downloaded statements and provided in the court. I have not done detailed analysis of his bank records.
Are you aware that there are charges from North Carolina on his accounts and credit cards from the dates in question for these offenses?
I have never looked into that, so I'm not aware.
Okay. Would that surprise you if there actually were?
I would have no knowledge of whether or not that they are there.
Okay. Well, let's go to that exhibit real quickly.
Okay.
Have you seen, just out of curiosity, do you know what the state's currently offering your brother with regards to a plea deal?
I do not.
Okay. Do you know what the minimum sentence range he is looking at for any of his charges?
I know that there's a range for depending upon which charge.
And what is your knowledge
I
of what
would-
the range is?
It could be anywhere from a couple years to life in prisons.
Okay. And are you aware of how old, have you seen the actual incident report from the offense?
I have not.
Okay, let's show it to you. Just out of curiosity, would you let him be alone with your 11 and 13-year-old daughters?
He has spent the night here since his release from jail, and he has been around both of my daughters.
Would you leave him unsupervised around your daughters?
I would.
Okay. Let me pull up the actual incident report.
Your Honor, I don't understand the relevance of this witness going through the incident report.
It's
Judge-
a character witness called by you, and I think we have to allow cross-examination.
Okay.
But timeliness.
This is probably my last few questions, Judge. I'm going to show you what's already been introduced into evidence as Exhibit P14.
Lacey is coming back in, and I don't know if that's Ms. Whitaker having problems with her.
Yes. Yes, Your
Okay.
Honor, that's me. My computer is dying, so I'm coming in on my phone.
Okay.
Okay. And are you aware, Mr. Whitaker, that the alleged victim ended up in the ER with major injuries from this reported force by your brother?
I am not. I knew that she had been taken to the hospital based on the fact that I was in federal court when he was being at his bond hearing there.
Okay. And now you're aware that she suffered serious injury, is that right?
I see that here on the victim report.
Okay. And does that change your opinion on the concerns you would have about leaving your children unattended with your brother?
I saw all 7 felony charges my brother was charged with by North Carolina, and I still allowed my brother in this house, sleeping in the house 8 feet away from my daughters, and I have no concerns with my safety of my children around my brother.
Okay. Sitting here today, do you believe he committed this offense?
I have not seen any of the facts on this, so I have no idea whether or not he did.
Okay. And you believe it's in these children's best interest to go see their father behind prison walls?
Since you objected to it earlier, I will once again state that I believe that it's in the best interest of children to maintain relationships with their parents in whatever safe form fashion that the court deems allowable, and that the experts are much better suited than I am to answer that question. But I believe that contact should be remained.
Okay. Thank you. I pass the witness.
I don't have anything further for this witness, Your Honor.
Okay. So then, Mr. Whitaker, Mr. Dusty Whitaker, you are excused as a witness and you are free to go. I'm going to remove you from the Zoom. The rest of us are going to be in a 10-minute break, and we'll call Miss Lisa Whitaker after that. Thanks. We seem to have lost Lisa Whitaker in the waiting room. Maybe she'll come back in.
That's fine, Your Honor. I was thinking about calling her, but for time management purposes, I'm going to go with my client, and I suspect that we'll go right up to lunch.
All right.
And-
Let's wait for, I don't see Michelle Locke back on screen yet. So let's give Miss Locke a minute to get back. It's all right. Okay. Miss Locke is back, Mr. Kazin.
Sorry.
Well, just the thing we caught up on is he's chosen to not go forward with Miss Lisa Whitaker for time. And so he's going to call his client.
Okay.
All right.
And Your Honor, if it's all right, I'd like to put on everybody's radar that I have a witness at 1 o'clock. So
Yeah, so I think we'll break at noon and then we'll come back at 1. That's going to be my plan. If you're done, you're done. If you're not done, you're not done. We'll come back to your client because he's going to be available.
Yes, Your Honor.
All right, then, let's go back on the record. At this time, Mr. Kazin, you are recalling Mr. Whitaker, but calling him as part of your case in chief. Is that correct?
That is correct, Your Honor.
And then I believe we've already sworn Mr. Whitaker in. And so he is still under oath, and I will ask him to unmute himself.
Let's spend some time talking about your proposed spreadsheet and property division. These figures that we have on the spreadsheet, to the best of your knowledge, are they true and correct, at least as of the dates that are in the notes files?
Yes, sir.
With your skills as a financial advisor, did you help me craft this personally?
Yes, sir.
So let's talk about how it operates just a little bit. First of all, do you see that down down here, let's take it all bit by bit. Is there
Judge,
any-
do we know what exhibit number this is? I'm sorry, I just can't see it from the screen.
Yeah, it's R40.
Okay, thank you.
Let's go through it bit by bit. Is there anything about the top section with just the brokerage and banking accounts that you feel like needs to be clarified?
No, I can walk through it if you'd like.
Sure. So what do you think is most important to touch on first?
Well, just to point out with this spreadsheet, what we've done is we actually have all of the corresponding exhibits over on the right that match to the values that are on the spreadsheet. And so up at the top, it's pretty straightforward. The bulk of our bank accounts are currently in Lacey's market savings, Wells Fargo checking, and her Wells Fargo savings. At last we checked, my bank accounts were pretty low balances. The next section is our brokerage accounts. This includes 3 accounts at Charles Schwab. One thing you'll see here.
Judge, I'm gonna object to narrative.
Judge, I can break it up, but this is in keeping with your prior.
I know, but that was with a fact witness, not with the party witness over disputed issues. I mean, frankly, I have a lot of questions. I mean, this always happens, and I always tell lawyers this. It's very hard. You both know, and your clients both know the estate, and it's really hard. This is the hardest part of this trial for me because I can't tell what's what and what is in dispute and what's not in dispute. But I'm not really for sure that narrative, even if it would be helpful to me from Mr. Whitaker, is appropriate. So I'm just telling you, I'm still a bit lost in this portion of the trial because, as you'll remember, you represented to me about 3 weeks ago that there really wasn't much dispute about anything involving the community estate. And now it feels like there is a lot of dispute about the community estate. And so the trial is kind of ever changing on that point. That said,
oh, sorry.
I think you need to do the best you can, Mr. Kazin, to break it up with questions.
Certainly.
Recognizing, both of you need to recognize, though, that I am a bit lost here.
And I think Mr. Case and I are going to work over the lunch hour because there are a bunch of numbers that we do agree on. The question is like what the court does with wasting claims, the reconstitution claims, but some of the basic numbers aren't necessarily in dispute other than some tracing stuff. But Mr. Case and I think we'll work diligently over the lunch hour to make it a little more clear for the court.
Thank you. And it may just come down to one thing that I would like you to do is just literally by questions. Like, what are the questions this court needs to answer about the estate? It's just almost like you do to a jury, because I think that is where I'm getting a little bit lost. Like, it's like, well, and then also this. Oh, and then there might also be this. And so we just need to figure out what sort of fact questions are in dispute that the court needs to answer.
All right. Thank you, Your Honor. Thanks for the guidance.
Yes, thank you for the direction.
So, Mr. Whitaker, going off of what the court just said, we're going to focus on the major discrepancies between what we've got and what Miss Whitaker and her counsel have provided to the court. So, in your mind, what is the first major difference between the two spreadsheets?
The major difference, I believe, is just the split. And, for the most part, I believe the numbers of the account values are pretty consistent. There's some of her account values that we don't have still to this point, to include Venmo and her health savings account and some updated, bank information. But those are the major discrepancies.
Okay. Do you see where I'm pointing here at your IRA with LPL?
Yes, sir.
Okay. Is that item the character of it, and what I mean by character, when I mean community or separate, is that in dispute?
I believe so.
Okay, so we've got over here an exhibit number, and I'm gonna open that and we can walk through it and we can explain your position versus theirs. So why don't we do that now?
Well, we don't know their position yet, which is a little unusual.
Well,
Judge, I'm going to object as to non-responsive.
Yeah, I mean, that is non-responsive. So I'll sustain that. I said I would sustain the objection. I think sometimes, Mr. Kazin, your feed cuts out. I don't know. I'm not really for sure, but I do think kind of blanks over when I roll sometimes, but did you hear me now?
Yes, Your Honor.
Thank you.
So, Mr. Whitaker, when did you start your retirement account?
I started my retirement account in 2006.
And where were you employed then?
Ameriprise Financial.
Okay. Do you recall approximately how much you contributed before your marriage?
Roughly between Ameriprise Financial and USAA, somewhere in the range of $250,000.
Apologize, Your Honor. I'm trying to find something. When did you stop contributing to your retirement, Mr. Whitaker?
I resigned from USAA in June of 2017, and I think my last contribution was mid-June of 2017.
Have you looked at the contributions that you made between the time that you got married and the time you stopped contributing to that account?
Yes.
What is this document, if you know, sir?
This is a summary of how we were able to backtrack into my separate property for my retirement account.
Okay, so roughly how does it work? Walk us through it.
Well, if you could go to the
Judge, and I'm going to object to this in its entirety. He has not laid the foundation that he's an expert to testify to any of this, number one. Number two, Mr. Whitaker is not listed as an expert to any of this. And this is not, I don't think it's appropriate testimony to come from Mr. Whitaker on this particular issue.
Your Honor.
Overruled.
Yeah.
Overruled.
So, Mr. Whitaker, walk us through how this summary works.
All right, well, if you could go to the next page, that'll show the USAA tracking. Should be right here. So, Mr. Kazin, the challenge with my 401k is after I left USAA, at some point, they changed 401k providers from Congruent to Fidelity. I had all the records of my 401k plan, which are now in Ms. Whitaker's possession and haven't been provided to us. We subpoenaed the 401k companies, and unfortunately, we were unable to receive the actual statements. So what you see here is USA provided us with my pay stubs from the time of marriage until the time of my resignation. And how this page here works, Mr. Kazin, is on the first column that has financial data, that was my contribution to the 401k. The second column is I had an 8% match from USAA, which was their contribution. And the third column was a retirement bonus I received every February. In the fourth column that has financial data, it shows all of my contributions from the date of our marriage on December 12, 2015. And if you scroll down, it shows the final amount, which I contributed $66,400 to my retirement account with USAA from the time I was married to the time I rolled it over.
Did you make any contributions after you left that employment?
No, I did not.
Does this chart that we're looking at with USA tracking cover all contributions made during marriage?
Yes.
Okay. So am I understanding you correctly? So do you have a statement? If I understand your testimony a moment ago correctly, you don't have a statement right before marriage, do you? Correct?
I don't have it in my possession.
Okay. And that would have been the case whether we would have had Mr. Metz who was designated a financial expert. You wouldn't have had that anyway because of the change in plan administrators.
That's
right. All right. And so if you don't have a statement that predates the marriage, these contributions, which you've just now testified, are the only contributions made during the term of your marriage to it. Is that how you sort of backed into the number?
That's correct.
Okay. So what is the remainder of this data that we have here?
That's a good question. If you go back to the last page. So Mr. Kazin, because we didn't have the statements, there were only 6 investment options available in my 401k plan. We used the most favorable investment option over that time period, which was the S&P 500. To assign a growth rate to each of those contributions. And as you'll see in the column, if you'll slow down and go back up, You'll see in the column right next to the S&P 500% change until the time of my rollover. In some cases, it was 20 and 35%. And so based on providing what we believe is a very conservative and favorable investment figure for the community property amount, it grew from $66,000 to almost $75,000 over that 18-month period.
Judge, I'm going to renew my objection as he has not been qualified as an expert to testify to some of the things he is currently testifying about.
Your Honor.
Now I'm going to overrule that. I allow a lot of leeway. Again, you have to make rulings. I'm consistent on this in all of my family law cases, and I allow parties to testify on their own tracing. I think I can also distinguish between where he is a party and where he is an expert in the interest of time. I know he hasn't been designated as an expert, but I allow parties to testify about their own property routinely. It's a little more careful here. I know you want to point it out. You pointed it out. I've overruled your objection. I just wanted you to understand my ruling in light of your objections.
And I appreciate it, Judge. I just know there's like S&P statistical historic data contained in this report. And I understand that parties testify to the nature of their estates. I get that. But I guess the concern is the extraneous information that is not.
The fact that he's more sophisticated than most parties who testify about financial matters, I don't really feel comfortable holding that against him. I have to be honest. And
Okay.
so that's just where we are in this case.
Thank you, Judge.
Go ahead, Mr. Kazin.
Mr. Whitaker, do you remember where we were and what you were saying?
Yeah, so I contributed 66,400 by assigning a aggressive growth rate to the community property. We made an estimate, and I say I made an estimate that there was approximately $75,000 of community property at the time I rolled it over in July of 2017, which was a total balance of $345,000. And on the first page, you'll see that $75,000 makes up roughly 78% of the total value of the account at the time of rollover.
So it says here at the top of this row, percent separate property. I think you misstated it a second ago when you said community.
That's correct.
This column is what you estimated at the time of the rollover. You believed it was 78% separate property. And then as of today, what is your calculation of how much you think is separate property?
Yeah, so once I rolled the account over, it's my understanding that all interest and dividends are community property. And so there's a column there, the fourth column, that outlines the interest and dividends. And we assign those to the community property. I assign those to the community property each year, which reduced the percentage of separate property over the years after that from 78 to 73%. Now, Mr. Kazin, I understand that this is not an exact calculation. I attempted to use very conservative numbers in favor of the community property. And, because we didn't have the 401k statement, what I would be asking the court here is if they don't feel that my 73% number is conservative enough to reduce it to, say, 65%, I think would be, something reasonable there.
You have confidence that if that adjustment in favor of the community estate were made, you have confidence in that circumstance that you're more than adequately accounting to the community estate for its portion?
Yes, sir.
Okay, so let's go back to your I want to go back to your proposed spreadsheet. Now, where we were when we began discussing it, I was pointing right here. You see my cursor under retirement. That's the full balance without accounting for the separate portion. Is that correct?
That's the balance as of October 31st, yes.
And the manner in which we addressed what we think is the 73% is over here under a negative number. Is that correct?
Yes, sir.
In that way, removing it from the community estate, putting that removal also under your column mathematically works out to that amount being your separate property. Is that generally correct?
Yes, sir.
Now, there's another item here, beach nut home proceeds. What is that?
I purchased a house in December of 2012, several years before marriage. When Lacey and I were married, we quickly bought a house in Circle C in which we moved. I rented out that house for 2 years after marriage. And then upon our next transition, we were looking to move to Spanish Oaks. And at that time, the idea was that we would sell this house so that we'd have more resources available to be able to purchase the $1.5 million house we bought in Spanish Oaks.
So I'm showing you Respondent's Exhibit number 51. Do you know what this document is?
It's from the sale of my home.
And you received this amount from the closing sale of the home that you purchased and sold before. You purchased it before marriage, but you sold it during marriage, correct?
That's correct. And this amount was transferred to Goldman Sachs into an account that we had over $500,000.
For a Respondent's Exhibit 51.
No objection.
51 is admitted.
And I'm showing you now another document. It's labeled Respondent's Exhibit 52. You know what this document is?
Yes, sir.
Okay, what is it?
This is a joint account statement from Goldman Sachs, our savings account, in February of 2019, where the sale of my home was wired to.
Okay, I offer Respondent's 52.
No objections.
52 is admitted.
Now, this last item it's currently under reimbursements dash community to H as separate property, but it's this last item here. It says business goodwill. What is that, sir?
So in spending time, my understanding of how to trace business goodwill is that it's separate property to the degree that it is, goodwill from you. And so the way I interpret goodwill is that, my education with my MBA, all of my licenses, my financial designations were what went into the goodwill, and the name of my company was part of the goodwill as well. And with that, the bulk of the clients that I used to start my business, I acquired in 2010 to 2014 prior to marriage. And they were my clients from the day I sold, up until the day I sold the business.
We're showing you Respondent's Exhibit number 42. What is this document? Mr. Whitaker, can you hear me?
Oh, yes. This document is the final sale of the business, which shows that the goodwill component was 5%.
Offer Respondent's 42, Your Honor.
Can we go back to the top of it again? Because I don't know that.
Yes.
Please. Oh, no objections.
Is this 42? Is that what you said?
It's Respondent's Exhibit 42, Your Honor.
42 is admitted.
So these three items are a significant difference. Would you agree from one of the biggest issues that's really a community property difference between our position and Ms. Whitaker's? Would you agree with that?
I would agree that those three items and her Roth IRA.
Okay. Incidentally, how does your spreadsheet address the taxes on the sale of the business?
So this year we've received $955,000 from the sale of my business, of which roughly $465,000 has already been distributed from the trust accounts, and there have been no taxes paid on that $465,000. So Mr. Kazin, what we'd ask the court to do is address that taxation, which is based on a 20% taxation, is $92,830. That is going to have to be paid on the funds that are already distributed to the Internal Revenue Service this year. And our spreadsheet attributes, based on the distribution of assets, 50% of that taxation to me and 50% of that taxation to Mrs. Whitaker.
Okay, and so why is this other line item not even, whereas the money received already is even? Explain that.
So there's still another $465,000 roughly that has not been distributed. And what we would ask the court to do, we're estimating taxes on that to be $98,169. And what I would ask the court to do is whoever receives the portions of those distributions, they would be attributed the taxes.
Okay.
And they would get, they would be the ones that pay the taxes. So if I received $100,000, I would pay the 20%, which would be the $20,000 on it.
So the main difference between these two lines here is One is money already distributed. The other is yet to be distributed money. And that's for the court to decide who's going to get the money. But your suggestion is you get $1, you pay a tax on that dollar as far as the undistributed money. Is that correct?
Yes, sir, that seems fair.
Okay. So let's talk about her Roth. You said there was a Roth that you disagreed with as far as the difference between how Ms. Whitaker treats it versus you. Where is that on this spreadsheet?
It's on the first page under retirement accounts.
Which is it? This Victory Capital Roth?
Yes, sir.
The one that's 28,746?
Yes, sir.
Okay, what is the issue there?
So we made 2 contributions to this Roth IRA in 2017 and 2018. There was a loophole in the tax code. Since she did not have a traditional IRA, we were able to make a non-deductible contribution to a traditional IRA and then immediately roll it into her Roth IRA. And those contributions were somewhere around $12,000. In the statement that they were provided in 2019, her account was like $18,000. So of which, more than half was funds that we contributed to the account. And I believe that's why Ms. Desai had some challenges tracing it.
Okay, did she in fact trace it?
There was no tracing provided to us on this Roth IRA.
Okay. Now, there's a Roth that you have as well that I want to ask you about, but it's way down here below the line. Can you explain why?
Yeah, so I had a Roth IRA prior to marriage. During marriage, I was unable to contribute to it because I had a traditional IRA. So I wasn't able to take advantage of the tax loophole of making a contribution to a non-deductible IRA and then immediately converting it to a Roth IRA.
Have you made any contributions to this account during your marriage at all?
No, sir.
Does Lacey Whitaker's spreadsheet treat this as community property?
Yes, sir.
Based on all that you've just said, you believe it's not community property at all, even in part?
No, I don't believe it's community property.
Now, one other thing that you won't find on our spreadsheet that is a major difference is child support. Do you recall how that was treated on Lacey Whitaker's proposal?
Yes, sir.
Okay. Why is it that you disagree with the idea of a lump sum in any amount being set aside out of the estate at the moment?
Well, I've been very forthcoming. I love these children tremendously and I want to provide for them. And, I've consistently said that I am comfortable paying the maximum guideline. If you go to the page up, we've proposed a split of the remaining future payments of the business, which would provide me with $12,500 a month. After paying taxes and child support from that $12,500 a month, that would leave me around $7,000 a month. And that's after my expenses in the worst case scenario that I'm incarcerated. That would be after the full payout. I would expect I would have somewhere between $275,000 to $300,000 after tax money from those payments that conservatively invested would give me somewhere between $30,000 to $35,000 a month that I would be able to, just that one investment, use to be able to pay the remaining 12 years of child support.
Their spreadsheet suggests a lump sum of $100,000 going directly to the Office of the Attorney General. If I understand Ms. Whitaker's testimony correctly, she's suggesting the same number of monthly child support that you are suggesting. Are you able to pay full guideline child support if you are not awarded a decent amount of the community portion of the property?
I think just it could impact my ability until we're on the other side of this situation, which we don't know what the outcome is going to be yet.
I see under your articulation, you figure with your numbers that the net estate is 2.419 million. You're asking for a 55-45 division of that number. Do I have that correct?
Yes, sir.
And if the court were to request a copy of this spreadsheet in Excel format, is it something that, for example, if the court were to disagree with, let's just take this, well, let's take this number here, $138,000 worth of wife's possessions. Let's say she figures it's only, the court figures it's only worth 50. How how easy is it to manipulate this in Excel format if someone simply needed to make some adjustments?
I think the spreadsheet's very simple to make those adjustments, and what it also accounts for is going to be the line in the miscellaneous assets under DAK, where when you manipulate that number on that untaxed amount that's currently in the DAK trust, that's going to adjust the estimated taxation to the party that it's awarded to.
So down here, just to interpret what you just said, the difference that you see in these two numbers is tied to mathematically the division that you're inputting here. Is that correct?
Yes, sir.
And so if the court were to, let's say, increase the amount to the wife's column to, let's say, $100,000, is there a macro that will go ahead and make that adjustment here so that the party receiving the dollar pays the tax on the dollar?
That's correct. That number would change to $20,000.
But otherwise, if a value change that the court finds in the first column or the second column is necessary, the court need only just change those directly in there. And how does it work on the other side as far as what to allocate if the court wants to change the allocation?
It's simple. You just move it from one column to the other.
But one of these columns has a formula and the other is blank. Is that correct?
Yes, sir. The formula is in the first column.
Okay. So the way it works is the net column is here, and then one of these two columns, but not both, has a formula in it, and you only tinker with the side that has no formula. Is that correct?
Correct.
The rest of the math is done for you and throughout the Excel format. All right. Your Honor, we're 3 minutes to noon. I can stop here. Can we resume?
I think it is a good stopping point. That works for me. Let's go off the record. Off the record, I wanted to ask you and Ms. Locke if you could send your Excel format spreadsheets to 201.submission@traviscountytx.gov. If you could please do that.
Yes, Your Honor.
Your Honor, I
go ahead.
will. And one other thing that I want to suggest, I've got a version of this, and I'll just show you it very, very quickly because I think this might be useful. I've got a version of this in Excel that actually has the colored. In other words, if the court wants to know precisely what to change, you can change anything here in the light tan.
Yeah, that'd be great. If you could send that to me and Ms. Locke, and then Ms. Locke will send us her manipulable version as well.
Sure.
And copy you on it.
What I've
as
done
well.
with this, though, is to give you the idea that please don't touch this column. Please don't touch this column. It'll only throw things out of shape. But you can make your own determinations about the right value found for both plus value and minus value. And then you can manipulate the who gets what over here in column E.
Understood. I got it.
Okay.
Ms. Locke, are you still there? You disappeared from my screen for a second, but
No, I'm still here, Judge.
sorry. I think the screen will you stop screen sharing for a minute? The other question I had, Ms. Locke and Mr. Kazin, you're not really far off on child support. You're just disagreeing on method, I think. And one thing, at least that's what it sounds like to me. It's not amount, it's method. I'm getting nods on that. It's not amount, it's method. Do you even know, Ms. Locke, if you can put $100,000 with the AG's office? Like, is that something
you can absolutely prepay child support. Sorry, Judge, I did not mean to cut you off. I apologize.
No, it's okay. I guess I wonder if it would be something between you and Mr. Kazin that rather than putting it with the AG, you could have a required evergreen account sort of managed by the brother who's, or with you having POA or something to pay child support. I wonder if you thought of something like that. I'm just giving you a heads up. I don't love putting money with the AG. I would rather not put money with the AG. I've had very bad experiences with AG over time and a lot of mess ups that they have done that have caused a lot of confusion in cases rather than corrections in cases. So I would like you to explore. Other ideas. I'm giving you as best direction as I can, as good a direction as I can. I don't want to argue about it. I am telling you, I, as a judge, I'm not going to put that amount of money with the AG. So think of other ideas.
Yes, Your Honor.
That might work.
I do.
I mean, if y'all agree to it, that would be one thing, but it sounds like it's not agreed to. I'm open to some sort of account. I just really would prefer it not being with them.
Understood.
All right. Thank you. I will see everybody back at 1:00.
Thank you.